Great. Well, we'll go ahead and get started. First, I would like to welcome you to the Heritage Foundation and thank you for coming out for our annual event, Scholars and Scribes. At this event, we've gathered some of the leading legal experts who will discuss and debate and examine some of the court's most interesting cases, as well as get into some of the potential cases for next year. We'll begin with our scholars panel and then move into the scribes. The person moderating our scholars panel is John Malcolm, who is the Rule of Law Program's Policy Director and the Ed Gilbertson and Sherry Lindbergh Gilbertson Senior Legal Fellow. John specializes in criminal law, immigration, national security, and religious liberty at the Heritage Foundation. He certainly brings a wealth of legal experience in both the private and public sectors to his research here at Heritage. Prior to joining Heritage last year, John served as General Counsel for the U.S. Commission on International Religious Freedom, as well as being a distinguished practitioner in residence at Pepperdine Law School. From 2004 to 2009, John was the Executive Vice President for the Motion Pictures Association of America, and prior to that, he served as a Deputy Assistant Attorney General in the Department of Justice's Criminal Division. From 1990 to 1997, John served as an assistant U.S. attorney in Atlanta, where he was assigned to fraud and public corruption section. He was honored with the Director's Award for Superior Performance for his work as an assistant U.S. attorney in the successful prosecution of Walter Leroy Moody, who assassinated an 11th Circuit judge and the head of the Savannah chapter of the NAACP. Malcolm began his career as a law clerk for a federal district court judge and a federal appellate court judge. He also was an associate with the Atlanta-based firm Sutherland, Aspel, and Brennan. In addition to his duties here at Heritage, he is the chairman of the Criminal Law Practice Group of the Federalist Society. He's a graduate of Harvard Law School and holds a bachelor's degree in economics from Columbia College. So with that, I'll turn things over to John to introduce our first panel. Thanks, John.
Thank you. Thank you, Rachel. I will try to be brief. Welcome, everybody. We are very, very fortunate to have a very distinguished panel with us here today to discuss some of the cases from the past term. I will, I think by necessity, since we want to hear their remarks and get to your questions, give them each an introduction that is way shorter than, in fact, each of them deserves. The first person that we will hear from is Chuck Cooper. Chuck is a graduate of the University of Alabama Law School, and after that he clerked for Judge Paul Roney on the 11th Circuit. He served as an Assistant Attorney General in the Office of Legal Counsel during the Reagan administration. He is a founding partner of the firm of Cooper and Kirk. National Law Journal has named him as one of the 10 best civil litigators in Washington, and he has argued several cases before the High Court, including this past term the Prop 8 case, Perry versus Hollingsworth. We will then hear from Tom Goldstein. After graduating from American University Law School, Tom clerked for D.C. Circuit Judge Patricia Wald. He is a founder of the law firm of Goldstein and Russell, and he also teaches a Supreme Court litigation clinic at the Harvard Law School, just stopped doing the same thing at Stanford Law School. In addition to teaching the Supreme Court litigation clinic, Tom has argued 28 cases before the High Court, including 3 this past term. He is known to many of us as the founder of SCOTUS Blog. SCOTUS Blog has received, it's indispensable for those who follow the Supreme Court. It has received numerous awards, including a Peabody Award for excellence in electronic media, and Tom has also received several accolades himself, including in 2010 being named by the National Law Journal as one of the 40 most influential lawyers of the decade, and being named by GQ as one of the 50 most powerful people in Washington. And then we will hear from Stefanos Bibas. Stefanos graduated from Yale Law School and then clerked for Justice Anthony Kennedy on the Supreme Court. I believe, by the way, Chuck, I left off that after Paul Roney, you clerked for Chief Justice Rehnquist, and I'm sorry about that. So Stefanos clerked for Justice Kennedy. He is a professor of law and criminology at the University of Pennsylvania Law School, where he is the director of UPenn Supreme Court Clinic, where he litigates on a wide range of Supreme Court cases. He is also the author of a new book entitled The Machinery of Criminal Justice. And with that, let me turn it over to Chuck.
Well, excuse me. Thank you, John. It's always a pleasure to be here at the Heritage Foundation, even when it is my unhappy assignment to discuss a couple of cases that I think were very wrongly decided, and one of which I argued in the Supreme Court. So let me get straight to that. The cases I've been asked to take a look at with you this morning are, of course, the Windsor case, the Doma case, the Hollingsworth case, Proposition 8, and the Shelby County case, the Voting Rights Act case. Before I guess I get into them, I should say it's a real pleasure to be on this panel with old friends, Stefanos, John, and of course the very powerful Tommy Goldstein. The Windsor case was the term's blockbuster. I think the most anticipated case, that and the Prop 8 case, of course, of the term, the two gay marriage cases. It involves Section 3 of DOMA, which defines for all federal purposes, and that includes some 1,000 plus federal statutes and benefits of various kinds, defines marriage as between a man and a woman. The case was brought by a lesbian couple, or I should say one partner to a lesbian couple, who had been married in Canada and whose marriage was recognized as valid in the state of New York. It was not recognized for federal purposes, however, and the IRS assessed a very substantial estate tax on the surviving spouse under New York law, Ms. Windsor, and she sued for a refund from the IRS, arguing that DOMA Section 3 violates equal protection and due process components of the Fifth Amendment to the United States Constitution. The case had a very unusual procedural background. Although the Obama administration entered upon the defense, some believes a rather tepid defense of DOMA initially. While the case was pending, President Obama and Attorney General Holder concluded that this provision of DOMA is unconstitutional, that heightened scrutiny should be applied, and they abandoned the defense of the case. The House of Representatives intervened through BLOG, the Bipartisan Legal Advisory Group, and entered upon a very robust defense of DOMA at that stage. The District Court and the Court of Appeals both invalidated Section 3 of DOMA, the Solicitor General taking a cert petition to the Supreme Court before judgment, actually before the Second Circuit had rendered its decision. That too is very unusual, but certainly not unprecedented. And the Second Circuit then seemed to kind of hurry up its decision, and it rendered the decision striking down the case. The case presented two fundamental issues, one jurisdictional, one on the merits. The court held that it had Article 3 jurisdiction because the United States' refusal to pay, even though it agreed with the plaintiff, its refusal to pay, its enforcement of Section 3 of DOMA, provided the plaintiff with the standing necessary to bring the suit in the district court. And then the order by the district court requiring the IRS to pay, even though the administration refused to comply with that order, provided the Solicitor General in the United States standing to take an appeal from the district court and to seek review in the United States Supreme Court. It was no particular matter that both the plaintiff and the defendants were on the same side of the case. That didn't destroy the concrete adverseness necessary for an Article III case or controversy, because Blogg, the intervener, provided the concrete adverseness and therefore overcame any prudential concerns that the court might have for resolving the case. On the merits, the court, as I'm sure you've probably heard, invalidated DOMA, Section 3 of DOMA, basically emphasizing that the regulation of marriage has always been, in this country, a vitally important and exclusive province of state governments, and that it's at the pivot of the state government's regulation of all domestic relations. And that theme runs throughout the court's opinion, Justice Kennedy's opinion for the court, that in this circumstance, the federal government engaged in a discrimination of an unusual nature, because it departed from the historic federal practice of deferring to state definitions of marriage and to state domestic relations laws. And it was that unusual discrimination that the court said would require a careful review. And the bottom line was, the court basically said that the overriding purpose of Congress in enacting it was to express moral disapproval of homosexuality and of same-sex couples, and that effectively reflected a bare desire to harm them, as opposed to any of the other neutral justifications that the Blogg had asserted and were present in the congressional record. Chief Justice Roberts dissented, Justice Scalia dissented, and Justice Alito dissented, and I commend them to your attention, and we'll probably get a chance to get into them as we proceed. I haven't got much time left. The Proposition 8 case came into existence after the California Supreme Court had declared, as a matter of state constitutional law, provisions, that California's pre-existing definition of marriage as one man and one woman was invalid under state constitutional law. The court, Proposition 8 then was passed by a narrow majority of California voters, and the lawsuit was brought by two same-sex couples challenging it under the 14th Amendment due process and equal protection claims. After a trial, the district court held that Proposition 8 is unconstitutional on every grounds that the plaintiffs had advanced. And the state refused to defend the statute, as you know, and it was left to the proponents, the official proponents, to bring a defense, to intervene in the case, and to defend the validity of the statute. The case then was appealed by the proponents, not by the state defendants. Court of Appeals certified the standing question of the California Supreme Court, which ruled unanimously that official proponents stand in the shoes, essentially, of an attorney general who has defaulted in his obligation to defend the validity of a state enactment. And so it was that authority that the Supreme Court ultimately rejected in holding that official proponents of an initiative do not have Article III standing to defend that initiative in federal court. Even though they do in state court, they do not in federal court, because essentially they're not public officials. They are not agents of the state in the sense that they're public officials, and private individuals can't be vested with that kind of authority. The irony pointed out by Justice Kennedy of that ruling is that the very purpose of the initiative process in California and the many other states, 26 states, I guess, who have it, is to control their own public officials. But this standing ruling essentially gives those very same public officials an effective veto over initiative measures, at least if they can find a judge, as they did in this case, that was very friendly to the plaintiffs and the defendant's view there. We'll have to, I guess, defer discussion of Shelby County since my time is not only up, but I'm a little bit into the very powerful Tommy Goldstein's time, and I don't want to do that.
No.
But the Shelby County, the bottom line of Shelby County is the court invalidated Section 4 of the Voting Rights Act, which is the coverage formula, which brings certain states, mainly the southern states and a few other jurisdictions, under this extraordinarily intrusive pre-clearance requirement where any voting change has to be pre-cleared before it can be implemented, pre-cleared by either the Justice Department or a three-judge district court. The court basically concluded that times have changed since 1965 when this coverage formula, which is based on voting statistics essentially, was put in place. Times have changed dramatically, and that record from 1964 can't possibly continue to justify the continued application of Section 5 under that coverage formula. So with that, I turn over to Tommy Olson.
Thanks so much, Chuck. I join Chuck and Stefanos, and thank you all for taking the time to be here. We really appreciate it. I also do want to say that while Chuck and I, no doubt, I think, probably disagree on the bottom line of the Proposition 8 and DOMA cases, that the country owes him a debt of gratitude for having taken on the question. It's my view that our legal system only works if there are the best advocates on both sides of every legal question, and his extraordinary efforts to do what I think actually is correct under the Constitution, which is to make sure that the views of the proponents of Proposition 8 get advocated. And I don't understand the Supreme Court's ruling to the contrary, that nobody has standing to defend Proposition 8. It was a remarkable piece of work, and he's to be congratulated for it. I'm supposed to talk about three less important cases, and so that we have the opportunity to talk about things like Windsor and the gay marriage cases and Stefanos' criminal law cases at greater length, I'm going to try and trip through them relatively quickly. They involve affirmative action, or rather a non-decision on affirmative action, gene patenting, and administrative law. The Fisher case was supposed to be a huge deal because it represented yet another instance where Justice Kennedy was in dissent during the O'Connor era at the Supreme Court. But Justice O'Connor, of course, retired, was replaced by the more conservative Justice Alito. And in those areas where he dissented then, and it's an important question, the court has tended to revisit those decisions and overrule them in name or at least in substance. And so it was to be with affirmative action, we all assumed. This is a challenge to the admissions program of the University of Texas at Austin. It had two parts. Part one was that the top 10% of the class of any high school at in Texas got admitted to UT Austin, and part two was that after the Supreme Court in the Grutter case 10 years ago had held that you could use race as a factor in undergraduate admissions, that too could be a factor for whether you got into UT Austin. And so everybody assumed that the Supreme Court would cut considerably back on the Grutter case now that there was a more solid conservative majority, and it did not happen. Instead, months and months and months after the court had the case under submission, it was argued in October, and we came to the end of June, the court said, the court, by a wide majority, with only Justice Ginsburg dissenting, although dissenting vigorously, said two things. The first is that if a state or a state university tells us that it really does need diversity in its classes, we're going to defer to that judgment unless and until we're asked to overrule Grutter, which we weren't asked to do in this case. But when they make that judgment to which we defer, we are going to rigorously scrutinize whether you in fact need such a race-based program or instead could accomplish the same thing through race-neutral measures. Send it back to the Fifth Circuit to figure out what it is that we mean. And I take it what happened in the Supreme Court is that both sides of the court decided that they had something significant to lose by not coming together, as they had before in a recent case involving the Voting Rights Act, in a decision that kind of kicked this can down the road. Conservatives had the prospect of losing Justice Kennedy on the question of whether race and racial diversity actually is a compelling governmental interest. The conservatives taking the view that the Constitution instead requires color blindness generally. And the left of the court realized that it had a lot to lose in terms of a finding that the University of Texas program was unconstitutional. So I expect to see this question, whether in the form of this case or another case, back at the Supreme Court in a few years. I also think there's something to be said for the idea that the court only tries to bite off only so much in any given term, so that it didn't want, in the wake of the Voting Rights Act decision, to have a very conservative ruling on race. It also deferred till next term, effectively, a ruling on whether, under the Federal Fair Housing Act, you can have disparate impact claims, that is discrimination without intentional, purposeful discrimination. And it also has agreed to take up the Chouette case from Michigan on the question of whether you can pass a state referendum that bans affirmative action programs. So I think they prefer to space these things out. The Myriad case is whether Myriad Genetics owns your genes. It turns out that the good news is no, it does not. Myriad discovered a very important pair of genes, BRCA1 and 2, which you can identify a mutation that in women is a significant indicator of different forms of cancer. But rather than getting a patent on a test for the genes and the mutation, Myriad was granted a patent on the genes themselves, and the USPTO, the Patent and Trademark Office, granted a lot of these patents. And the Supreme Court said, look, you might have discovered these things inside the human body, but you didn't make them last time we checked. And so we're not going to allow you to have a patent on them. Now, if you do things with them or you make tests about them, well, then that's another kettle of fish, and maybe you can get a patent on those. It didn't decide that question. You might not be able to get a patent because it might be obvious. It might be obvious how you got them. But I don't think that the decision ultimately, it has kind of a symbolic importance. It did make this test more easily accessible to women in the short term because the price, because Myriad was the only one who had it, was in the thousands of dollars, particularly for the uninsured. But most of these patents were, in effect, coming to the end of their exclusive term anyway. They had been issued quite a long time ago, so it didn't really affect the biopharmaceutical industry. The last case is the City of Arlington case. Full disclosure, I won it. Worst disclosure, I lost it. It is an administrative law case, which in Washington is more important than it is in other places. The question here was, under the law, an agency interpreting a vague statute that it has the power to interpret gets what's called Chevron deference. That is, if the agency has a reasonable interpretation of the statute, the courts will defer to it and it'll become the law. The question in this case was, what if you don't know for sure that Congress gave the agency that power to interpret the statute? You take a step back. And here it was a vague provision of the Federal Communications Statute. The FCC said Congress wanted us to interpret that. We said no, it didn't. And so the fight was, should you defer to the agency's view that you should defer to the agency? That is, the agency said Congress gave this to us, and we disputed that. And the Supreme Court said that you do defer to the agency if it's in a broad package of statutes that are the agency's responsibility. We lost this case in part because Justice Scalia was having a fight with the late Justice Brennan about this. Justice Brennan was no longer engaged in the debate, but Justice Scalia had not forgotten it. And they debated it in a case in 1986, and it actually has significance for a much different question that was actually presented in this case, and that is there are claims that agencies are exceeding their jurisdiction in the sense of doing something that's generally beyond their power. And Justice Scalia thinks those kinds of claims are for the agency. This case got kind of wrapped up in that one, but it's a significant win for agencies and their ability to point to different provisions of federal law and say, those are our responsibility, and when we interpret them, courts have to defer to us. There you go.
Thank you for having us and for this wonderful panel. I hope you'll indulge me in trying to set out a few general themes I see at the risk of overgeneralizing before I get to the criminal cases. A couple things to keep in mind. Number one generalization I think is fairly accurate is there is nobody on this court who is a consistent proponent of judicial deference. I think Justice Scalia in the gay marriage cases complained with some justification, well, the majority is not deferring to the legislature. But the day before, many people have pointed out, it was the right hand of the court that was not deferring to Congress in the Voting Rights Act and its specific findings. So there are some justices who defer in some areas and not others. Justice Kennedy, my old boss, may be the least deferential to the branches. Again, this is overgeneralization. He defers in criminal cases, let's say, but there's not a consistent proponent of judicial restraint on the court the way that the late, John Marshall Harlan the Younger might have been, at the risk of overgeneralizing. There's much more judicial activism on both sides in this court, and I use that in a neutral sense of independently scrutinizing the branch's own findings. And again, there's some exceptions this term. City of Arlington is one where a majority of the court is willing to defer to administrative agencies. But by and large, this is not a deferential court. Second thing I want to say is, when you look at the criminal cases that I'm going to focus on, I think this is an area in which the breakdown is not always left-right. And again, I want to set aside death penalty cases and the juvenile life without parole cases, maybe even set aside Fifth Amendment cases. But there are a number of cases where the breakdown is not left-right. It is formalist or theorist versus pragmatist. And in that breakdown, Justice Scalia and often Justice Thomas wind up oddly on the criminal defendant side. And Justice Breyer oddly often winds up on the state side. And we saw that again and again. The Fourth and Sixth Amendment cases this term showcase that very well. Justice, at least on the cases that don't involve the exclusionary remedy, but on Fourth Amendment rights, Justice Scalia was on the defendant's side in every non-unanimous case, and Justice Breyer was on the government's side in every non-unanimous case. This has the further odd effect that Justice Scalia, who is known for liking bright-line rules, oddly, in an area like the Fourth Amendment that sometimes has rules and sometimes doesn't, like sometimes he's on the side of a rule, which is you got to have a warrant in Maryland versus King. And sometimes he's on the side of, well, at common law, this was a reasonableness determination. There are areas that don't admit of these neat kind of rules. So let me run through some of the Fourth Amendment cases here, and then maybe gesture briefly towards the Sixth Amendment, because these are areas in which I think the press, with the notable exception of present company, often misses some of these nuances in trying to portray it as a left-right, liberal conservative divide. It just doesn't break down some of the criminal cases that way. One of the cases I'm assigned to talk about is Maryland versus King, a hugely important case, as Justice Alito noted, which is, can the government take a cheek swab and do DNA testing of arrestees? Everyone in the case conceded the government has the power to do this of people who are convicted of crimes, at least convicted of felonies. But the question is, can you do that upon arrest? And in Maryland, Alonzo King was picked up for an assault charge. His DNA was tested, though it wasn't tested by statute until sometime after he was arraigned, etc. He was booked. Turned out he was implicated in a rape that had been unsolved. He's convicted of the rape, and there's a motion to suppress. And so the question is, everyone agrees it's a search, and it's a search where you have to go inside someone's body, but it's not. On the other hand, it's not as deep as taking a blood draw. Is that a reasonable search? And so 5 members of the court, which is 4 of the conservatives plus Breyer, say that it is. And the opinion's written by Justice Kennedy. And the dissent, interestingly, is Scalia plus the other 3 liberals on the court. And Justice Kennedy basically adopts the argument that it's a search, but it's a reasonable search. It's not too big an intrusion on privacy, and the government interests here are very, very weighty. It solves lots of unsolved crimes. It's like the 21st century equivalent of a fingerprint. It could tell us whether someone might commit crimes on the inside. It could be relevant to bail adjustment hearings, etc. And the dissent's point, and Justice Scalia oversimplifies the law a little bit in this area as well, where we've allowed suspicionless searches in the past, it has been for not for purposes of solving other crimes. That's oversimplified a little bit, but this is a classic trying to solve other crimes issue. It's not like a fingerprint to make sure who this guy is, and it's certainly not being done quickly enough to be relevant for mistaken identity on this crime or bail determination. In the future, we may get to the point where we can scan people's DNA in time. A very important limitation in the Kennedy opinion is, number one, the opinion says this is for serious crimes, and it's not at all clear that that limitation will hold, and whether that will be extended to traffic stops, etc. several examples in the Kennedy opinion suggest that the result would wind up being the same in that situation. Number two, and perhaps more significant, a limitation in the opinion is, well, this is just for the junk DNA, for purposes of identifying. If we were using this to determine someone's race, paternity, genetic conditions, other things that would reveal intimate detail unrelated to who this person is, we might have a different result. And so we might break out the taking of the swab itself from what you do with the information from the swab. And I think that actually has to be a pretty serious limitation for privacy purposes to keep it solely about identification. And the opinion does seem to suggest that is a very significant limitation, and the rule might come out differently if you were trying to probe someone's heritage or something else. The other case that I want to focus on here, Missouri versus McNeely, is a drunk driving case. Someone is stopped for drunk driving, takes a sobriety test and fails it. Ordinarily, you have to take a breathalyzer test, but someone can refuse, and so he physically refuses to comply. You can take away someone's driver's license for that, but can you compel him to then go get a blood draw to see whether or not he was in fact drunk enough to qualify for punishment and aggravated punishment under Missouri law? And so, can you do this without a warrant, right? Missouri's logic was, well, the blood evidence is decaying moment by moment. We can't wait for a warrant because over time it's going to dissipate in the blood. We can't wait long enough. Basically, 8 members of the court, everyone except Justice Thomas, say, no, you can't routinely bypass a warrant. 5 of the members of the court don't want to lay down a rule. 3 of them say, well, get a warrant if you can, and if you can't, it'll be dispensed with. But 5 members of the court, which includes Scalia and Kennedy, say, well, we have to have some kind of case-by-case approach. Look at whether you can get a telephonic warrant as a particularly significant example. And interestingly, here, so in King, Justice Scalia wants to have a rule, which is you can't do these kinds of searches. But in McNeely, his attitude is, no, we ought to have some kind of case-by-case balancing approach. And so a lot of it seems to depend on the degree of the intrusion and whether warrants are viewed as a safeguard or not. This court does not have a consistent approach to that. The final thing I just want to note is, as I said, these are Fourth Amendment cases with searches. I think the Sixth Amendment cases, likewise, a lane involving facts triggering mandatory minimums, can't just be found by a judge anymore. And I think it's very significant that these are not cases in which the court is deferring to the government. The court makes up its own independent mind. And the same thing was true in another Sixth Amendment case that our clinic won, Pew, that we're going to, actually an ex post facto clause case, we're going to decide on our own whether or not something is a rule that triggers punishment. But this is not a deferential court.
In a moment, we'll get to questions from the audience. I believe there's somebody with a microphone, yes? Supposed to be. If not, then just speak up. I would ask, though, if the panelists have anything that they would like to say, perhaps that they've heard that they would like to respond to before I get to questions. Yeah, Chuck.
I would like to make a couple of observations, I guess. One in response to Stefano's presentation. First of all, I really disagree with the idea that a court not being deferential to the legislative branches, whether it be Congress or to the state legislative activity, is judicial activism. I think the court's responsibility is to apply in good faith and to apply the Constitution's restraints on legislative authority in good faith according to its best judgment as to what those provisions originally meant. I also think it made some very interesting observations, Stefanos, about the makeup of the court and kind of shifting majorities. That one of the unexpected, I think, things about the Proposition 8 was the makeup of the majority that held there is no standing. That majority was composed of Justice Roberts and Justice Scalia, as well as Breyer and Kagan and another one of the liberal justices. Justice Sotomayor, on the other hand, was in the dissent. So that was unexpected, and one can't help but wonder the extent to which their views on the merits of the case may have influenced their views on standing. The final point I'd make is in response to Tom's observation about the court's tendency to be incremental in the steps that it takes, and the trail of breadcrumbs that it lays towards its ultimate destinations. We saw that in the Shelby County case. Just a few years ago, that decision was very well telegraphed in a case called Northwest Austin, I think it was, where they made pretty clear that Section 5 was, in today's realities, an overreach by the federal government. Query whether or not Justice Scalia was right in his dissent in the Windsor case, the DOMA case, when he predicted that the next shoe to drop, as he put it, would be the state laws defining marriage as between a man and a woman. He thinks that was inevitable. Justice Roberts' dissent, on the other hand, emphasized all of the federalism-based themes in the majority opinion in an effort to give lower courts, presumably, plenty of encouragement in terms of distinguishing the DOMA case in the many pending decisions or cases now dealing with state marriage laws.
We do indeed have a microphone, so I would ask if you have any questions to raise your hands.
I think Tom had a response.
Oh, I'm sorry, Stephanos, you had something you wanted to
I
say?
think Tom.
Go ahead.
wanted
Oh,
to
no,
say
I was just.
Oh, Tom, I apologize.
Thank you. No, I do think that the post-Windsor, post-Perry kind of litigation world is a fascinating place. There are really, I think, two very significant battles that are likely to make their way to the Supreme Court, whether same-sex marriage advocates want them to or not. One is the Perry question, and that is there a federal constitutional right to same-sex marriage? If a state defines marriage as between a man and a woman, is that constitutional? And you would have thought from the huge cheers outside the Supreme Court on the day the case came down from same-sex marriage advocates that the Supreme Court had actually decided that and had ruled in their favor, but the justices, as Chuck has pointed out, came nowhere near resolving that question. And the second issue is, what about Section 2 of DOMA? We frequently do say that DOMA was struck down, but a very specific provision of DOMA was struck down, and that's the one that Chuck described, and that is that the federal government won't recognize a same-sex marriage. But there's another provision that says that a state is not required to recognize a same-sex marriage that is valid from another state. That fight is going on now in Pennsylvania and a bunch of other states, and the question is, does the logic of the Windsor decision that says that these marriages are entitled to equal dignity extend to requiring not just the federal government but another state to recognize them, which would mean that if you are in a state, say Alabama, that doesn't recognize same-sex marriage, can you go to Massachusetts, get married, and come back home and require the state to recognize that marriage? That's a very significant, very difficult question. There is this equal protection ruling from the Supreme Court, but traditionally the doctrine has been that states get enormous deference in their decision on whether to recognize various marriages. Common law marriages are an example. So those two questions, I think, are headed back to the Supreme Court. And I say that even if same-sex marriage advocates didn't want them to, because it used to be that interest groups really could control these sorts of things. If you look at Brown versus Board and that body of cases, well, the NAACP really picked and chose the litigation that it wanted. And in Perry, it was famously a fraught question in the gay rights LGBT community whether the California case should go to the Supreme Court. People were very worried that the justices on that side that the justices would reject the claim. But now the groups don't have that kind of control, and any couple that wants to say, I mean, say you're in Tennessee and you believe that you have a right to get married as a same-sex couple, then you bring a lawsuit, and that case can go all the way to the Supreme Court. So it will be fascinating. I think inevitably these questions will get to the justices in the next 3 or 4 years.
It'll go to Supreme Court, assuming the state's public officials, elected officials, defend the statute. That's apparent. That now is an essential ingredient of getting something to the United States Supreme Court.
I just want to add two things. First of all, when I talk about deference, or for lack of a better word, activism, I was using it in a descriptive term, and it's become loaded in a lot of ways. It's not a very helpful word anymore. But I think on First Amendment issues, we didn't have a big blockbuster First Amendment case this year. But this is a court that, whether it be commercial speech about drugs or campaign finance or dogfighting, like almost all the justices have a kind of are very unwilling to defer to legislatures on this, with the possible exception of Justice Alito. But Justice Alito is part of the Citizens United majority, so even on some issues, and second, in terms of gay marriage, I think the structure of the Windsor opinion is a very interesting one. There's going to be a lot of argument coming up about what it means. And my read of the oral argument was Justice Kennedy seemed to have been very influenced by a brief filed by a bunch of conservative scholars making federalism arguments against DOMA. Ultimately, the Windsor opinion speaks primarily language of equal protection, but it's this, there are multiple pieces going on where he says a state has decided to recognize a protected class. This is a traditional province of states to decide who is married, etc. Once the state has decided this, for the federal government to single out some people recognized as married by a state, but not other people for certain benefits, for the federal government not to give these benefits, is a denial of equal protection. If you take that federalism component of the state designating the people first seriously, it is not at all clear that that is going to translate into a pure equal protection ruling that same-sex marriage is required. And I take that to be actually pretty significant part of Justice Kennedy's opinion, not window dressing. Now, one of the problems is it's not a very clearly written opinion, so it's not pellucid, and there's a lot of argument about what it means. But I do think the federalism arguments were significant enough that you can't just take Windsor, as Tommy says, I agree completely, as a vindication of same-sex marriage when it gets fought out state by state.
The last thing I'd mention is that the dissents are really great indications of the different strategies of different justices. The Chief Justice looks at the Windsor opinion and says, well, this doesn't mean all that. This isn't going to be cited for same-sex marriage around the country. It's a federalism opinion. Scalia's response is, the world is ending today. This is, the clear indication that the court's going to hold that you have a right to same-sex marriage. And so they have different strategies. The Chief Justice Roberts taking the long view, trying to avoid bad consequences of a decision that he couldn't stop, and Justice Scalia, raising alarm bells.
And if I could just emphasize one other point that Tom has made, and that is that the net of the Perry decision, the Prop 8 decision, is simply this, that given that the proponents did not have standing, the Supreme Court didn't have Article III jurisdiction, neither did the Ninth Circuit. Its decision was vacated. And so the net of it is that we are left with simply a single district court judge's view with respect to the constitutionality of Proposition 8 and the state's ability to define marriage traditionally. That decision is not even precedential in his own district court. So Perry provides no guidance at all on the ultimate substantive issue.
Let's get to a question over here. We have mics on both sides. Go ahead, back there.
So reading through the Shelby County opinion, I thought it was interesting that there's a lot of discussion on the majority side of evidence that entrenched voter discrimination has really significantly disappeared, and evidence on the dissent saying, well, yes, but people are trying to sneak in these sorts of measures all the time. There was very little discussion of either the bail-in or the bail-out provisions elsewhere in the legislation, and does the fact that states can get themselves out of Section 4 preclearance weaken the majority's case that this is just sort of an increasingly unreasonable standard based on past evidence? Or does the fact that states can bail in make this sort of less of a horrific outcome than the sort of liberal side of the court might think?
Well, the bailout provision was ultimately decisive in the case that I mentioned earlier, this Northwest Austin Municipal Water District, I think it was, where the court remanded the case for further proceedings under the bailout provision. It held, and I don't precisely recall the rationale, but that particular covered jurisdiction could pursue the bailout method, and so it wasn't necessary for the court to reach the larger question. That wasn't available in this case. Frankly, I can't recall why, but the court did reach the question that it essentially ducked a few years ago. It is true that there is a method for bailing out, but it is a very difficult process, and doesn't really provide any significant relief that, at least in my mind, ought to result in the court deferring a decision or upholding this coverage formula on the basis of the availability of that bailout.
Yeah, so my 2 cents on this, just to give the context, Section 5 of the Voting Rights Act says you're going to have to get pre-clearance. If you're covered, you have to come to us, the Department of Justice, or a federal district court in Washington if you want to change your voting system in any way. Section 4B, here's our list of jurisdictions that are subject to it. Then there are other provisions that say, look, if you're on the list, you can come to the government and say, we have a proven history of not engaging in discrimination. We should go off the list, so we don't have to prove it to you ahead of time anymore. That's called bailing out. There's another provision that's called bail in that says that if the government proves that a jurisdiction has engaged in violations of the 14th or 15th Amendments in voting, then they can get subjected to preclearance. And so the idea here was you shouldn't look at the list as being too old and too static, conservative majority, because the list is dynamic. It can grow or it can shrink. And the court was unpersuaded about this, I think, because it regards Section 4 and 5 as essentially an insult to the dignity of the covered jurisdictions. And to say that to bail out you have to go back to the government or back to the court is no great relief from that insult. It may well be that bail-in has long-term consequences because what the Supreme Court didn't do was strike down Section 5, which is the notion of preclearance. You can still have preclearance. That means that Congress could go get a new list, could create a shorter, more updated list, but it also means that the Department of Justice can sue places like Texas or Shelby County and prove violations of the 14th or 15th Amendment so that going forward they will be subject to it. There are actually a list of about a half dozen places that are still subject to preclearance right now because they were bailed in through that litigation remedy. But I don't think the conservatives were persuaded, and they obviously weren't, the Shelby County won the case, that the prospect of getting on off the list or that the list could be enlarged was enough of a change. They believed that Congress was acting irresponsibly and that there was, in effect, a kind of racial lockdown in Congress where nobody could oppose the Voting Rights Act. Now, that's an aggressive view of how you respond to legislation because, and Justice Scalia famously argued at the oral argument, as he is wont to do, rather than asking questions sometimes, that, in effect, the legislative process was completely broken and this had turned into a sort of racial entitlement. And they wanted to really force Congress, as they had said in the Namundo case a few years ago, take a look and make a shorter list. The idea that conservative House Republicans are going to say now, Alabama, you're in, Louisiana, you're out, seems very difficult to imagine as a practical matter.
And particularly because any kind of neutral new test coverage formula would inevitably embrace jurisdictions that don't have a particular geographic concentration in the South. The voting registration and voter turnout statistics nowadays there are some northern jurisdictions that have much worse statistics than in the South. So this would be a much different map, any neutral map anyway, that came out of Congress in the aftermath of this decision.
Roger.
Roger Pelon with the Cato Institute. Is this microphone working?
I'd speak up a little bit.
All right.
It doesn't appear to be working well.
Yes. This is for Chuck. Would you say a little bit more about the standing issue in the Hollingsworth case, and in particular the effort by the Chief Justice to distinguish the cases that Justice Kennedy was raising? There's something very disquieting about the people having issued a referendum and the state not rising to defend it, and the distinction between the state as the officials and the state as the people who have passed this referendum.
I'll be happy to address that, Roger. The main case dealing with this issue of standing was the Karcher case, where the Supreme Court recognized that when a state, that state was in New Jersey, as I recall, the state's attorney general refused to defend the constitutionality of a measure. I think it was a moment of silence statute. The court recognized that legislative officials, the Speaker of the House, the President of the Senate, could intervene and take over the defense in the default of the state's officer who normally does that. We argued that the proponents were in precisely the same shoes as those legislative officers. And we relied upon a particular passage, especially from the Arizonans case, that said which distinguished proponents in Arizona as not having standing because, as the court put it in the Arizona case, we are aware of no Arizona law appointing initiative sponsors as agents of the people of Arizona to defend in lieu of public officials. We said that's exactly what California law does provide, as a unanimous opinion of the California Supreme Court made clear. Its constitution may as well have said in terms that if the Attorney General defaults in the defense of an initiative, the official proponents are responsible to step into the Attorney General's shoes and to defend that statute. That's how the California Constitution was interpreted by the court. We said, therefore, we obviously are golden under California law. The Supreme Court decided, no, you've got to be public officials. Again, I pointed out the irony, or at least I emphasized the irony that Justice Kennedy pointed out, of giving those very same public officials a veto power. But to my mind, the glaring flaw in the notion that that only public officials can be the agents of the people in defending an initiative, it comes from the very passage that Chief Justice Roberts relied upon, where it said in Arizona's, we're aware of no Arizona law appointing initiative sponsors as agents of the people of Arizona to defend in lieu of public officials. Chief Justice Roberts seizes on the word agents and says, well, these aren't agents. They don't satisfy the restatement of agency with fiduciary duties and control and the rest of it. But the whole point of that passage is they've got to be in lieu of public officials. By definition, they would be private parties, not public officials by definition. But he requires them to be public officials. So what agents, if you have to have public official agents in lieu of public officials, you've accomplished nothing. So I appreciate that question, Roger.
Since we got started a couple of minutes late, let's take one more question. Yes, right down here.
First of all, I want to thank you for taking the time to be here with us. Mr. Cooper, regarding the DOMA case, could a Commerce Clause argument be made pointing out to the disparities between state laws providing benefits and insurance coverage which affect the economy across state lines? Thank you.
This would be a Commerce Clause challenge to DOMA, you mean? Well, I'll dodge the question by saying I honestly haven't thought about that element of DOMA. I don't recall if there was ever a time when that issue was raised in the history of the DOMA case, which I didn't litigate. I would want more time to think and ponder that question, but my instinct is that no, that to the extent those types of economic regulations are governed by a pure rational basis analysis, then it seems to me that Congress would plainly have rational economic reasons to draw the distinctions that it did. I don't believe that the court did apply in the Windsor case a rational basis analysis. It doesn't particularly, it doesn't really identify what level of scrutiny, if any, it is applying. It seems rather to be saying that because moral disapproval was at the root of Congress's decision, and it relies on legislative history for that judgment primarily, but because that was at the root, it trumps everything else. It doesn't matter what else the Congress may have had in mind. That would be a entirely values neutral justification for the decision.
My 2 cents. So the Commerce Clause means different things in different contexts, and there are different parts of DOMA. I suspect your question is, look at Section 2 of DOMA, where it says Texas doesn't have to recognize a same-sex marriage that comes from Massachusetts, right? And the part of the Commerce Clause that we're talking about here would be a challenge like the healthcare law challenge, and that is Congress has no business regulating this question because it doesn't actually involve interstate commerce. And I think that there's an argument to be made there, certainly, that I don't know if it would succeed. That is, what in the world is federal law? We totally get Section 3 of DOMA, which says for purposes of federal benefits, you don't have to recognize the same-sex marriage. That seems like Congress's job for sure. But the idea that you could say that one state doesn't have to recognize a marriage from another, I suppose the answer is, well, by definition, the couple is moving from one state to another, and that might well be enough to sustain it.
Isn't that an attempt to get around the full faith and credit clause argument?
Well, yeah, this is all really, as I mentioned when I first discussed this next generation of questions, this all intersects with a body of law that says that states get lots of deference in their choices about these sorts of things, notwithstanding the general rule under the full faith and credit clause that if you have an agreement from one state, it's going to be recognized in another. That these kinds of essentially moral decisions are things that states get to make special choices about that often aren't subject to the full faith and credit clause. But now maybe there's a 14th Amendment right to equal protection that can't be violated.
Well, if I could just add, it seems very difficult to imagine, frankly, how a state could refuse to recognize a marriage valid in a sister state of a couple that had moved to the state that does not recognize same-sex marriage, and yet Congress could not do so. It's very hard to imagine that there would be that the state's judgment on that score would be free of any moral value judgments underlying it. And so it query why a state would be able to make that kind of judgment, but Congress cannot.
Before I turn things over to my distinguished colleague, James Swanson, please take a moment to thank our speakers.
Okay, great. If we could quiet so that we can begin the second panel today, the Scribes panel. I will say Heritage is so grateful to have such excellent Supreme Court reporters come today. They've done an awesome job throughout the year covering the court, and we are so eager to hear their additional insights now that the term has concluded. Moderating our panel today will be James Swanson. He is a senior legal fellow with the Heritage Foundation. His focus is on the Supreme Court and constitutional law. Previously, prior to joining Heritage, he was a senior fellow at the Cato Institute and the founding editor-in-chief of the annual Cato Supreme Court Review. He served in the Reagan administration as a legal advisor to the chairman of the U.S. International Trade Commission and in the office of the legal counsel at DOJ. He was a law clerk to Judge Douglas Ginsburg at the U.S. Court of Appeals for the D.C. Circuit. In addition to his contributions at Heritage, James is the Edgar Award-winning New York Times best-selling author of Manhunt, The 12-Day Chase for Lincoln's Killer. James has also been hard at work on his next book, which will be published this fall, and is on the assassination of President Kennedy. James?
Thank you, Rachel. We're fortunate to have with us today 3 of the top Supreme Court journalists in the nation. Nobody is better than Jess Braven, Adam Liptak, and David Savage, and I thank them for joining us. We call this event Scholars and Scribes, but no disrespect to the lawyer scholars who just spoke. Our scribes have something in common with them, an equally profound knowledge of the court and its cases. And in fact, the journalists might have a tougher job. The lawyers just have to worry about dealing with the justices and with their colleagues and opposing counsel. But the journalists not only have to match their legal expertise, they also have to explain the cases in plain language to everyday people, to a wide public audience. A long time ago, Chief Justice John Marshall said, "Any Supreme Court opinion should be written to be understandable to any educated citizen." Was it a century or 2 ago that the court abandoned that principle? And so these journalists are indispensable in helping the American people to understand what these cases mean, and more importantly, what the fallout is, what the consequences are. I'm going to try to say as little as possible so you can hear the most from them. But I'll begin with brief introductions of them, and then I'll turn it over to our panel. Each of them will talk for about 7 minutes. I'll invite them to react to what the others have said, and then I'll give a question to each of them, more of a thematic question based on the writings they've done all year about the court, and then we'll turn it over to you. Jess Braven covers the Supreme Court for the Wall Street Journal after earlier postings as the United Nations correspondent and editor of Wall Street Journal California Weekly. He's the author of the book Terror Courts from Yale in 2013, a new account of military trials at Guantanamo Bay, and Squeaky, the life and times of Lynette Ellis Fromm. You might remember she was one of Charles Manson's followers and attempted to assassinate President Ford. He's also contributed to a number of books. He's been recognized with the Elizabeth Neuffer Memorial Prize for coverage of the International Criminal Court, the American Bar Association Silver Gavel Award for covering the legal response to 9/11, and Wall Street Journal Team National Press Foundation Excellence on Online Journalism Award for coverage of healthcare. Prior to joining the Journal, Jess wrote for publications including The Washington Post, Harper's Bazaar, Spy Magazine, and evaluated scripts for a Hollywood talent agency, managed a campaign for a local school board, and in law school he served on the University of California Board of Regents and the Berkeley, California Police Review Commission. He's also, and having lived in Los Angeles, I'm especially excited about this, he led the effort to designate Raymond Chandler Square in Hollywood in honor of the hard-boiled crime novelist. Jess is a graduate of Harvard College and the University of California Berkeley School of Law. And Jess is going to begin talking about a couple cases. We're going to talk about a number of them today, but he'll begin with Fisher v. University of Texas, the equal protection question about undergraduate admissions, and he'll also talk about Perry and California Proposition 8.
Yeah, well, I've been given the 2 great anticlimax cases of the term to discuss. So we'll start out with these ones that fizzled, and then get to the more exciting speakers and more exciting cases that follow. Fisher versus University of Texas was, as you heard in the first panel, the follow-up to the Grutter and Gratz decisions from 10 years ago involving affirmative action in public university admissions. And for a number of reasons, it seemed that the court was ready to revisit its holding that really that consideration of race could be a legitimate tool in it to advance the compelling government interest of providing diversity in university enrollment. And that's because of the switch between Justice O'Connor and Justice Alito. The court quickly disposed of all sorts of procedural objections that Texas raised as to why this wasn't a good case to hear. They blew past the fact that the plaintiff had already graduated from college, that her injuries were hard to assess at this point, other than perhaps getting back her application fee, which I think the University of Texas offered to give her. It was not a class action. It was not based on representing the interests of other applicants who might be discriminated against. But nevertheless, the court decided to hear it, and it heard it early in the term in October, and we expected that while it was important, it might not take them the entire year to come up with an answer, and certainly not the answer they did. But the answer the court gave us by broad consensus. There were 8 justices participating. Justice Kagan did not, because the Obama administration, when she was Solicitor General, intervened at the circuit court to side with Texas. Of the 8 justices who took part, 7 remanded the case back to the lower courts for a trial. And the bottom line of it is really, in a sense, elevating Justice Kennedy's dissent from the Grutter case into the majority opinion. It was not now in that case, while he did dissent, he didn't dissent because he disagreed with the concept of diversity as a compelling interest. He accepted it. He felt that the University of Michigan Law School in the Grutter case had not demonstrated that the way it used race was in fact narrowly tailored to achieve that objective. And in this instance, Justice Kennedy, writing for the court, essentially requires Texas to demonstrate that while diversity is a compelling interest, the way it uses it in combination with the top 10% plan that you heard about in the prior hour is narrowly tailored to avoid any harm to applicants who are disadvantaged by it. So it will go back to a trial. Perhaps it looks that the court is punting this, but I think for higher education, which really strongly believes in racial preferences as almost a pillar of faith in the higher education establishment, their justifications are going to be subject to greater challenge and greater scrutiny. So in a sense, the way that this opinion did move the ball was to say that lower courts simply shouldn't take the word of university officials when they say what they're doing is necessary to achieve diversity. They have to show why this is the necessary way to do it if they're going to use race. The other case that we also just heard about, California case of Hollingsworth versus Perry, ends up being a case of tremendous importance in, I guess, civil procedure, but not too much about same-sex marriage or family law. And it is, the interesting, the mystery, perhaps we'll have to wait until the justice's papers are revealed in the 22nd century or whenever that occurs, but the justices who found there to be jurisdiction in the Windsor case for the Supreme Court to hear and get to the merits, who found there to be no jurisdiction in the Perry case, to explain how they reached different conclusions, because by many standards, it seems that the proponents of Proposition 8 are better situated to have standing and to create jurisdiction than would be the leadership of one chamber of Congress that's unhappy with the way the administration is defending a statute. Because California acted much the same way that the Obama administration did. The Chief Justice, famously criticized President Obama at oral argument in the Windsor case, saying, well, if he doesn't believe it's constitutional, why is he still enforcing it? Why doesn't he just drop enforcement of the Defense of Marriage Act and potentially let somebody, sue to enforce it or something? But the same thing was true in California. Governor Brown was enforcing Proposition 8 even as the state did not defend it. Same thing with the Attorney General. So while politically they said they disagreed with it, they thought it was unconstitutional, they still were refusing to issue marriage licenses to same-sex couples. So they were pretty much doing the same thing. And for a lot of the reasons you just heard, there seem to be some strong reasons why the proponents of an initiative in a state where the initiative process has given us so many hours of entertainment, why the proponents of an initiative would not have standing to defend it. And in fact, as it goes forward in the law books, the Perry case may end up representing a blow against the initiative process in general across the country, kind of diminishing the stature of initiative proponents everywhere, at least for purposes of federal law. But in terms of practical outcomes, it was the Perry case that had the immediate result, because right away, the Ninth Circuit almost immediately dissolved its stay. I guess they reasoned that there wasn't a jurisdiction for them to issue a stay, so the stay couldn't exist. And immediately officials began issuing same-sex marriage licenses. There was an interesting, if difficult argument made by proponents of Prop 8 why the state could not extend those marriage licenses, why the decision only affected the couples in the Perry case. But no one else in California, at least no one in official positions, seemed to agree, and immediately Proposition 8 essentially vaporized. So we'll see if there's any continuing litigation to keep it in force. But right now, the case that fizzled as a matter of constitutional law had a much larger immediate impact on the ground in California.
Jess, you actually have 2 more minutes if you'd like to take it. Otherwise,
Well, okay, I was misled. So speaking of that, so I think it's important then to talk about what the grounds are that at least were discussed by Prop 8 advocates for the theory that Prop 8 should not take effect despite the Supreme Court's ruling, or rather Prop 8 should remain in effect despite the Supreme Court's ruling. And they cited a provision of the California Constitution that says that administrative agencies of the state cannot cease to enforce a state law without an appellate court opinion striking down that law as unconstitutional. And if the Ninth Circuit opinion was vacated and there's no Supreme Court opinion, the only opinion was the trial court opinion, therefore no appellate court ruling, therefore administrative agencies not empowered to stop enforcing a law. And that question hasn't been litigated, but the immediate points that occurred to me were, one, the supremacy clause, that I don't know how a state constitutional provision can override a federal court's constitutional ruling. And secondly, whether or not the governor and the attorney general of the state are administrative agencies. Under the state constitution, the supreme executive power of California is vested in the governor, and the chief law officer is the attorney general. They direct administrative agencies, but are they themselves administrative agencies? And so I don't know that even as a matter of textual construction, that theory would apply to the governor and attorney general, whose views, incidentally, on Prop 8 were known when they were elected, at the same time that Prop 8 was enacted by California voters. So they were voters were at least of 2 minds in electing people who were publicly opposed to the same constitutional amendment that they were ratifying in 2008.
Thanks, Jess. Adam Liptak is the Supreme Court correspondent for the New York Times. He began covering the court in the fall of 2008, and he's also written a column sidebar on developments in the law since 2007. Adam's series on ways in which the U.S. legal system differs from those of other developed nations, American Exception, was a finalist for the 2009 Pulitzer Prize in Explanatory Reporting. And in 2005, he examined the rise in life sentences in the United States as part of a 3-part series. And following year, he and 2 colleagues studied connections between contributions to the campaigns of justices on the Ohio Supreme Court and those justices' voting records. Adam joined the New York Times as a copy boy after graduating from Yale University. He returned to Yale for a law degree, graduating in 1988. And after law school, he spent 4 years at Cahill, Gordon, and Reindel, one of the premier First Amendment firms in the nation in New York City, and Adam specialized there in the First Amendment. In 1992, he returned to the Times legal department and spent a decade advising the Times and the company's other newspapers and television stations and new media on defamation, privacy, news gathering issues, and he frequently litigated media and commercial cases. And he's taught media law at Columbia University Journalism School, UCLA, and Yale Law Schools. His work has also appeared in The New Yorker, Vanity Fair, Rolling Stone, and Business Week, and as well as some of the leading law reviews. Adam is going to begin by talking about Shelby County, Section 4 of the Voting Rights Act, unconstitutional. And Maryland v. King, does the Fourth Amendment allow the states to collect and analyze DNA swabs? And Adam, I'm particularly interested in Maryland v. King because in the day that case came down, my wife and I were attending a black-tie dinner at the Supreme Court. And at the end of the dinner, when the court staff started collecting the silverware and putting them in plastic bags, my wife said, "Take that fork. Don't let them keep the fork. They'll analyze it." So, Adam, please.
Thank you very much. It's great to be here with my friends Jess and David and with all of you. Maryland v. King, Stefanos covered it quite well. I have a couple of observations about it. It is, of course, the case that says you don't need a warrant to take a cheek swab of someone arrested but not yet convicted of a serious crime. And it's one of those cases in which Justice Kennedy writes the majority opinion and Justice Scalia writes the dissent, which is to say it's not a fair fight. If Justice Scalia is writing a dissent, he's not going to overlook shortcomings in your opinion. And this was one, and this is perhaps characteristic of the term in some ways, where, and this perhaps one of the gentlest things Justice Scalia has ever written, but it's a statement that could be said about much that happened this term. He said, "This opinion does not really contain what you would call a rule of decision." And you will see that in the major cases we discuss, where you're challenged to identify not just the standard of review. You would think it's rudimentary legal work to say what standard of review you're using, but even the constitutional provision you're relying on to strike down a statute. The other, I can't help but remark on, it doesn't fit into any thematic thing, but it's just my favorite line of the term. I'm not sure it's in the decision, but I think I'm paraphrasing fairly closely from what Justice Scalia said from the bench in Maryland v. King. He has a tendency, as you know, to go a little over the top. He said, "The proud men who wrote the Charter of Our Liberties would not have opened their mouths for royal inspection." In the age of Revolutionary War dentistry and before Altoids, I think that was simple courtesy. But let me pursue a little bit. So I don't know that there's more to say about Maryland v. King as such, except, as Stefanos has already pointed out, there's this odd and repeated switch where Justice Scalia, joining the liberal members of the court, is the great protector of the Fourth Amendment, and Justice Breyer, after an encounter with a burglar and a machete-wielding man in the Caribbean, may have turned into that old caricature of the conservative as a liberal who's been mugged. So anyway, let me turn to Shelby County. Let me run my first theme across several cases. I think Fisher does contain a rule of decision, but then it refuses to apply it. I think if honestly applied, the rule of decision announced in Fisher means if you truly apply strict scrutiny to holistic admissions processes, which are gauzy and hide the ball by design, it's going to be very, very hard for institutions of higher education to justify their race-conscious programs. We'll see what happens on the ground, but it was a funny kind of leapfrog where you announce the rule, but you decline to apply it to the case in front of you. Now, the other cases, the other major cases in DOMA, which David will talk about in Shelby County, the problem is that it's very hard to know what the rule of decision is. Shelby County, as you heard, on one level sounds like a perfectly sensible decision, right? This is a case where federalism is turned upside down. States enact laws relating to voting and yet have to come to Washington for permission before their duly enacted law becomes actual law. It has to be blessed by the feds. That is indeed a profound intrusion on state sovereignty. It's also the case that the data that justified that intrusion is very old and has changed substantially, and the coverage formula has not changed since the 70s. So that doesn't sound especially fair. And it is also true that this attaches a badge of shame to jurisdictions that may or may not still deserve it because the data is sold. So that's all true, and that sounds perfectly sensible. But then you want to ask the question of, well, so what actual provision of law does this violate? And bear in mind that the amendments in question, the 14th and 15th Reconstruction era amendments, specifically authorize Congress in this area because its framers were wary of the Dred Scott Supreme Court. And they didn't want the Supreme Court making these rules. They wanted Congress to make these rules. And Congress holds hearings and overwhelmingly votes and says, we still think this is a good idea. In fact, the Senate votes 98-0. Justice Scalia thinks that's evidence of something that the fix is in, that's unreliable, that an overwhelming vote can't be a good vote. And 98-0 is probably something he remembers because that's the margin by which he was confirmed. Then you can also ask the question of what standard is it? Earlier, Section 5 had been upheld repeatedly by the court under a kind of rational basis review. There was a suggestion in the 2009 case, Northwest Austin, that maybe the Bernie congruent and proportional standard applies. Here we have this major decision striking down a civil rights landmark that people bled and died for, and the Supreme Court neglects to tell us what standard it's using. It does rely fairly heavily, excuse me, on the concept of equal dignity of the states, equal treatment of the states, which sounds like that could be a concept you could put into the Constitution. It happens not to be there. There's this notion that you have to, new states have to be admitted on the same basis as old states, but states are discriminated against in federal legislation all the time, and it's very hard to know where this equal treatment concept comes from, except perhaps the 2009 case, Northwest Austin, where interestingly, and this is a theme that I think also runs through the cases, 8 justices, including 4 liberals, had agreed to sign on to that decision, including that language, only to find it cited back against them. I think you'll find that again in Fisher, where the liberals minus Ginsburg in dissent and Kagan recused sign on to that kind of language. You saw it also in another lopsided case about an Arizona law that required you to present proof of citizenship to vote. That was held to be preempted by federal law. But in the process, Justice Scalia, writing for the majority but joined by all of the liberals, planted some seeds for the idea that voter qualification is a matter uniquely reserved for the states.
Thank you, Adam. David Savage has been the Supreme Court correspondent for the Los Angeles Times since 1986. And working out of the paper's Washington, D.C. bureau, he's at an excellent vantage point to observe the High Court's actions, decisions, and changes over the past 3 decades. Prior to taking up the court beat, David was the Times education writer based in Los Angeles. And he's the author of the book Turning Right, The Making of the Rehnquist Supreme Court, published in 1992. And that book covered the efforts of the Reagan and first Bush administration to remake the High Court. He also writes a monthly column on the court for the ABA Journal and offers regular legal commentary on National Public Radio's Talk of the Nation program. David, who, for good or ill, I think for good, and the first John Marshall would agree, is not a lawyer. Maybe that's why he can explain these things even better to the American people, who grew up in Pittsburgh and holds degrees from the University of North Carolina, Chapel Hill, and Northwestern University. David's going to begin with some comments on Windsor, defense of marriage, and also City of Arlington v. FCC, that really fascinating case involving deference, the Chevron doctrine, and Scalia and Roberts, and what that all means. David.
I'm going to talk on, so maybe I can't get to that one. Before your comment about me as an education reporter, I can't resist. I was a young education reporter in LA, and one of my jobs, once a week, I'd have to go cover the LA school board. And at that time, there was this sort of skinny guy with curly black hair who was a student member of the Los Angeles school board. The most interesting character, because he would, when Daryl Gates, the police chief, came to talk about drugs, he would sort of question the police chief. His name was Jess Braven. He was actually the student member of the Los Angeles school board when I was covering it.
And I learned then how easy it is to manipulate the press. That, you just come up with one pithy line, and that's all you need. And so, it turns out that people in the Supreme Court learned that too. But no, actually, great. It was a great education for me to watch David then, and to continue to watch him today.
Well, I don't want to talk about standing or anything like that. I wanted to put in a few good words about the gay rights movement. And you would think, well, Heritage is probably not the ideal place for a talk about gay rights. But I would have said much the same thing had I been here 5 years ago about the gun rights movement at the time of the Heller decision in the Second Amendment. And it's really about the point that if you see a big change in the law in the Supreme Court, it's not because a clever lawyer has filed a brief that says, hey, how about equal rights for gays? And the justices say, My God, I never thought of that. It's almost always the case that it reflects a long-term sort of change in public thinking, or at least legal thinking. You know, if you go back 40 or 50 years, people thought the Second Amendment was archaic, sort of like the Third Amendment. And it was actually true that lawyers at that time said, you know, it talks about a well-regulated militia. And they thought it really had very little meaning. But beginning in the 1970s, the National Rifle Association made that phrase, the right of the people to keep and bear arms. They said it over and over and over again. By the time of the Heller case in 2008, it was a big deal in the legal world for the Supreme Court to say, yes, the Second Amendment gives you a right to have a gun. But 75 or 80% of Americans said, well, of course it means that. What else could it mean? You know, there had been this sort of fundamental shift in thinking, so that by the time the court decided that case, people thought very differently about the Second Amendment. Well, then go back 40 or 50 years and think about the idea of equal rights for homosexuals. In the sort of liberal Warren Court, the most liberal court we ever had, if there were homosexual scientists, diplomats who got fired by the federal government simply because they were what we would now say gay, they brought their cases to the Warren Court and they just batted them aside. They wouldn't even hear them. And you know, in the early 70s, the same thing. The idea of gay marriage of homosexuals, that didn't even raise a reasonable question. Now you get into about the 1990s, it seems to me the gay rights movement, and I don't know who I'm even talking about here, but in a very, I think, very shrewd way, pursued several really conservative aims. We want to serve in the military. We want to serve openly in the military. Do you remember that? Don't ask, don't tell. That was a big fight in the 1990s, and a couple years ago, the opposition just sort of went away and Congress repealed it. And the other was, we want to be married and raise children. You know, I mean, what more sort of conservative, in a sense, goal you could have is to take on the commitments, the responsibility of marriage, to raise children. Now, in the 1990s, Congress, when they passed the Defense of Marriage Act, there were no legally married gays. It was a phenomenon on the horizon, and the very far western horizon. I think a Hawaii court had talked about legalizing, but there really were no gay marriages. So Congress passed that, and then about 10 years ago, right after the Lawrence decision, marriages were legalized in Massachusetts and then now all through New England. And look what's happened. People were very afraid of that process. Over time, you can read the polls as well as I do, people's views have changed, and there's no longer that reflexive opposition. Public thinking has changed in a big way, and this year it was reflected at the Supreme Court for the first time. The Windsor case, which is what I'm supposed to talk about, is actually, I think in some ways, a sort of easy stepping stone case. It didn't require the court to say to any state, you have to allow legal marriage. It only said that there were tens of thousands of couples in Massachusetts, Connecticut, people who've been married for 5 or 8 years. They had very ordinary things. They said, we'd like to file a joint tax return. Or one of the women who's a plaintiff is a postal worker, and she wanted to put her spouse on the health care plan. Very ordinary stuff. And they said, you know, we want to be treated as other married couples. We just want the same legal rights. Nebraska and Utah and Alabama, you don't have to do anything, but we want equal rights. And so that was the issue that finally got to the Supreme Court this year. And I think Stefanos covered this pretty well, is that Justice Kennedy's opinion has two themes. One is marriage is a state law matter. We should leave this to the states. The other is it denies equal protection to single out this class of gay married couples and treat them differently. Now, if you paid close attention to the first, you'd think, well, the court's going to allow this to be decided state by state. 13 states allow gay marriage now, 37 don't. The second part of the opinion says equal rights. And as we know, Justice Scalia he told us, I know where this is going, don't be fooled. Down the road, if this is a matter of equal rights, sooner or later, the Supreme Court's going to say it's a matter of a constitutional right for gays to marry. I would be very willing to bet and predict the Supreme Court will recognize a right to same-sex marriage. The only question is when, right? It could happen 5 years from now, it could happen 15 years from now, but somewhere down the road when 25 or 30 states allow gay marriage, it'll become a constitutional right. And I think I'll skip FCC and the city of Arlington.
David, I will give you 2 more minutes because I want to hold your fond memory of Jess against you. So take 2 more minutes if you'd like. Otherwise, we'll
You
go.
actually want to hear about the city of Arlington? Tom did a good job arguing that case, but I thought that was a case, a very interesting case for conservatives. You ought to read the opinions, not about cell tower regulation, which was the subject. I think it's an interesting dispute between the Reagan-era conservatives and what I'll call the Obama-era conservatives. Justice Scalia, who came up in the Nixon-Reagan era, remembers when regulatory decisions were essentially made by interest groups in Washington and federal judges. When the Reagan administration didn't do the right thing on the Clean Water Act or the Clean Air Act, some group would go to court, they'd file a suit, a judge would say, yes, the executive agency needs to put out EPA needs to put out stronger regulations. Justice Scalia and none of the conservatives of that era didn't like that. They said, look, President Reagan was elected, he runs the agencies, you ought to defer to the executive agencies. Okay, now fast forward to the Obama era. All the regulations coming down the pike on the health care. Are we, the courts, we, the Supreme Court, going to defer to all the regulations that the Obama people put out, or are we going to exercise some real skepticism? In this case, Justice Scalia and Thomas are with the liberals to say, no, the old rule from the 1980s is the rule. We defer. Justice Scalia said the question is, these lines are going to be drawn by unelected bureaucrats or unelected, unaccountable judges. And Scalia says, I'll go with the unelected bureaucrats because at least there's a president in charge. And John Roberts wrote a really strong, interesting opinion saying, no, the regulations are sort of out of control, the headless fourth branch of government, and that the courts ought to step in and exercise more judgment. So it's a fascinating dispute, even though what they're deciding is a really trivial issue.
Thank you, David. Adam has his favorite line of the term. It comes from Justice Scalia, and I've got mine, also from Justice Scalia. Your raisins or your life. I'm disappointed that none of you have talked about my favorite case of the term, Horn v. Department of Agriculture and the Raisin Marketing Order of 1949, which actually has profound implications, I think, for takings, for government programs, for subsidies. And
how could we have overlooked it?
And it also produced a great line from Justice Breyer, who seemed to express shock that Congress passed legislation that would cause prices for goods to be raised to American consumers. I'm shocked that gambling is going on here. I'm going to suggest now we do a little round robin where you talk amongst yourselves about what you said. And can I suggest, if you'd like, any or all of you come to an issue that nobody's mentioned today. The report from the economist William Landis, Judge Richard Posner, and Lee Epstein, this theory that you've all written about or noted, that the Supreme Court has become the most strident pro-business court ever. Richard Epstein says it's a myth, the selection is wrong, the way of evaluating is wrong. So if, as you talk amongst yourselves now, if any of you want to bring that issue up, that'd be great, but I give the floor to you three to comment to each other.
Listen, what they say is not ever, but since World War II, and you either buy a political science way of looking at the court or you don't, but the data is very rich and very suggestive that the Roberts Court is the most pro-business court since at least World War II, and that the two justices most likely to vote pro-business who have sat in that entire era are number one, Justice Alito, number two, Chief Justice Roberts, which is to say the two George W. Bush appointees. I'm persuaded that it's correct. It's careful work, and it's completely consistent with what we saw last term, which was an excellent term for business, an excellent term for the Chamber of Commerce across many areas: arbitration, class actions, employment discrimination, tort preemption. You can argue case by case, and this one went that way. Some of them were unanimous, and Richard Epstein is a formidable scholar, but I don't think he really engages the study.
Any counter comments to that?
Well, we'll see how well that deference to administrative agencies point continues to operate, because the FDA said it was going to issue regulations to effectively nullify some decisions involving generic drugs. As you know, Justice Thomas a couple of years ago, and then the court reaffirmed this term, that generic drug makers are immune from suit under state tort law, while branded drug makers are liable under a prior decision by Justice Stevens. The reason being that generic drug makers have no authority to change the instruction labels and warning labels. They have to just copy the ones made by branded manufacturers, so therefore they're not responsible for the drugs not working and leading to horribly disfiguring results, which were the case this year. Well, the FDA said that it was going to issue a rule clarifying that generic drug makers can modify the labels when necessary, with the express purpose of counteracting what they think is an anomaly in the law. So we'll see when that gets challenged, once it goes through, if it goes through, how deferential the court is to that regulation issued by the Obama administration to essentially overrule some decisions of the Supreme Court. I wanted to quickly just throw in a couple points in response to David's note. One, news reports say that the Pennsylvania Attorney General is not going to defend that state's ban on same-sex marriage. So we'll see right away if the Perry decision has an effect on Pennsylvania's law. I don't know Pennsylvania law and whether the governor can step in. They're each independently elected, but that is the news reports from Pennsylvania, where the ACLU has already filed a suit seeking to overturn that state's ban. So that's something to watch immediately. But referring to David's point about how the gay rights movement has built over decades I guess the public momentum towards greater recognition of their rights. There was a document I looked at for a story that focused on another point the other day, but this is from 1972. It says, the conference voted to recommend that the current sodomy laws be changed. The conference believes that no private sexual act between consenting adults should be forbidden. Blah, blah, blah. Okay. Discrimination against homosexuals in hiring should be forbidden. And that was written by Samuel Alito in 1972 when he was a Princeton undergraduate and chairman of a student conference on privacy rights. So there have been all these years he's been working toward that end, and he's in a position to help give it effect.
Just one very small comment on the business issue. I actually think that the justices are more anti-trial lawyer and big lawsuits than they are necessarily pro-business. If you have a case like that they decided a couple weeks ago, it was American Express being sued by a coalition of restaurant owners, Well, restaurant owners are business, but the little restaurant owners, they were part of this big class action lawsuit. So what really seems to unite the court is if it's a big lawsuit, one of these giant lawsuits, what some people call entrepreneurial lawsuits, that's what they almost uniformly are against that, even more so, I think, than they are, quote, pro-business.
I agree that they have a self-loathing quality, that they think courts are the wrong place to get anything done.
Any more, Jess?
On this point, on the business point?
Or anything you'd like to say?
No, I'd like to hear what questions you have.
Okay. Well, before we get to the audience, I've a quick question for each of you. I'm actually going to put on my literary agent hat because I've got a book idea for each of you implied by this question. I've read all of your pieces that you've written in the past year on the court. And Jess, in late June, yeah, I really did, Adam. Jess, in late June, you published a piece entitled "The Tale of Two Justices," which I thought was a great book title. You suggest that Chief Justice Roberts and Justice Kennedy are involved in a curious, intimate, friendly and unfriendly dance where they're really behind the scenes vying for leadership of the court. And could you just comment a little bit more based on your Tale of Two Justices article?
Well, what I wanted to suggest to readers was that the real ideological pulls on the Supreme Court were not between the left and right, liberals and conservatives, but really between the approach to law of the Chief Justice and Justice Kennedy's approach as the most as a justice most often in the majority, and that on these pivotal cases, and of course we have that great exception last year in the healthcare case, but pretty much all the other major ones, we see that it's really where the Chief Justice is in the dissent, it's because Justice Kennedy is in the majority. And so in helping readers look at what the actual ideological spectrum of Supreme Court decisions is today, it's not between Justice Thomas and Justice Ginsburg or the Chief Justice and Justice Kagan. It's really between the Chief Justice and Justice Kennedy, whose own approach to things it is certainly on the business cases, on most of the law and order cases, we see him line up with the other conservatives. But when it comes to certain issues that really trigger his own special brand of justice, including things impinging on his view of individual dignity or state dignity, he will go his own way.
And Adam, a few things in your end-of-term pieces caught my eye. One of which you spoke about now. I don't know if you need to elaborate on it. You caught what you call the rightward drift of Justice Breyer and some of the privacy cases. But I think the book you'd write could be called The Roberts Plan, because you suggested we shouldn't take a freeze frame of the court at the end of each term. We should almost view it cinematically as a work of art in motion. And you wrote that Roberts is, quote, a canny strategist with his eyes on the horizon, patient, methodical. And I was struck by this line. You say the price of victory today for liberals in the Roberts court can be pain tomorrow. So talk a little bit about how you see the Chief Justice planting seeds and harvesting them a year, 5 years, 10 years down the road.
So I've said a little bit about that, and you can see examples of this, I think, in the voting rights case we talked about. I think there are seeds in Fisher that will ripen. There are seeds in that Arizona case that will ripen. And you certainly saw it in the run-up to Citizens United, where Justice Scalia, who wants to do everything right now, and I think Justice Kennedy's probably in the same boat, criticized the Chief Justice in Wisconsin Right to Life for faux judicial minimalism, for not doing today but taking it step by step. And there was a similar sense from Justice Thomas in his concurrence in Shelby County, where he says, what is this nonsense? We all know Section 5 is going down. Why don't we just say so? There's a paper that Cass Sunstein at Harvard just posted on SSRN last night, in which he puts the justices in 4 categories, and I won't go through it too closely. It's a very nice paper. They're heroes, and I think Kennedy and Scalia might be in that mode. You know, someone who wants to do the big thing and get credit for it. There's the mute in Alexander Bickel, the soldier, Felix Frankfurter, and there's the Burkean minimalist. And I think the Chief Justice fits into that mold. He's only 58 years old. He's going to be on the court for a long time. He's perfectly happy to take it step by step, but that's not to say he doesn't have a big agenda. I think he does, and I think race is probably at the center of his big agenda.
And David, based on your writings this term, your book might be called The New Equal Justice. And if I could just quote you, you write that this new view of equal justice on the court is, quote, skeptical of old liberal laws that put heavy emphasis on race and that are biased. And then you write that they're just as skeptical of laws that are biased against gays and lesbians. So talk more about what you think is the new equal justice, skeptical of the old racial remedies and of recognizing the new rights that you mentioned.
Well, I thought that was one of the interesting themes of this term, was that all the big cases at the end are about the question of equality, equal treatment. And it seemed very much like it was the end of one era and the beginning of another. You know, that affirmative action and the Voting Rights Act were the sort of late 1960s remedies for racial discrimination. And it took a lot of years and, you know, a lot of effort. And I thought among the conservative justices, there's definitely a majority to say that era is past. It's time to start winding these down. It was absolutely true that the Voting Rights Act in Section 5 was needed in 1965 or 1970, but it's a different world today. And then I thought it was interesting, at the same time, we're now starting down this new road of equal rights for gays. And that is going to be with the court, I think, for a long time. It's not going to be, you could tell with the way this played out that even the justices on the left, as well as some of those on the right, did not want to answer the question that was in Chuck Cooper's case, but that is there a right to gay marriage? They wanted to push that issue down the road. And so I thought this was an interesting term. It felt like one era of equal rights was coming to an end as a new one was beginning.
Okay, let's open it up for 10 or 15 minutes of questions. Right, in front here, next to Roger.
Ray Lajeunesse, National Right to Work Legal Defense Foundation. The flyer on this program mentioned as one of the major cases in the upcoming term the recess appointments clause challenge to the non-recess appointments the President made to the National Labor Relations Board. I'd like to hear your comments about that case.
That's one perfect for you two guys.
You know, we'll read those briefs when the time comes. It does figure into a little bit of what David said about the City of Arlington case. This is one of the, it's a profound constitutional question about when the president's recess appointment right ripens. It was the subject of two very broad circuit court opinions saying that only in the period between congressional sessions, which really limits it profoundly, the actual facts in the case involve a quite brief recess. And the Supreme Court added that question after the Solicitor General only wanted an answer to the broad question. But I think the point that goes to David's point is this is something that Republican and Democratic presidents have done in various forms for hundreds of years. So it may be that this would be a victory for business groups and conservatives as against the Obama administration today. But it's not for sure that a Republican president 6 years from now will be happy with that decision.
It strikes me that there's two wrongs here, and this case deals with one of them. The first wrong is that the Republican minority in the Senate is not allowing President Obama to fill just ordinary seats based on a majority vote. They're using the filibuster power to block a vote. And then Obama, sort of, in my view of things, it's sort of the second wrong, then overuses the recess appointment, when in a sense really not on recess, to try to fill those seats. Now, my impression is the likelihood is the Supreme Court will affirm the D.C. Circuit and say Obama had gone too far, because it seems strange for the president to be able to define the recess when, if the Senate goes away for the weekend and he says, okay, you're on recess, I'll fill all the, that seems going a little too far. I also think, though, from what I read in the papers today, it's possible Harry Reid and the Senate Democrats may solve this problem before the case gets argued, because they could repeal that part of the filibuster rule and say, look, when it comes to filling executive seats, not legislation, not judges, we're going to allow the president, if he's got 51, if there are 51 senators who will vote to confirm his nomination to fill an executive seat, then we're going to allow that nomination to proceed. So they could fill those seats with confirmed nominees, and then there wouldn't be a fight over recess appointments.
In the center here.
Hans von Spakovsky, Heritage. If you look at the stats on the Solicitor General and the government for this past term, usually the government wins the majority of the cases that they're in, either as a party or as an amicus. But in fact, in this past term, they lost the majority of the cases. I'm wondering whether you think that's a reflection on the SG, or is it a reflection on the legal positions that the administration is forcing them to take?
So the numbers collected by Adam Winkler at UCLA were that the SG ordinarily wins about 70% of the time in merits cases, and this last term it was only 39% of the time, which is a very, very bad record. A great deal of it is probably explained by an ideological difference between a liberal administration and a court that's dominated by 5 generally conservative justices. But I ran this theory by a Supreme Court advocate yesterday, and I said, so it's not the advocacy, it's the positions they're taking, right? And this person said back astutely, the position is the advocacy. You know, so at some point you have to attribute some of those losses to a failure of lawyering.
You know, I don't have as much of a sense this year as I did last year of the administration taking sort of far-out liberal positions that, remember last term there were several where they lost 9-0 in a wetlands case.
Hosanna Tabor.
The religion case. I've already blanked out on this term, but what were the, I thought the Obama administration, the SG was losing in a lot of criminal cases where they were just sort of taking the government's position, and they didn't really reflect a lot of ideology.
It didn't seem that the ones they lost were the big ones. I mean, I guess you could say their position in the Perry case was that a loss. I mean, you know, the court didn't adopt their point of view, but I mean, if it was a bad term for the SG, it was also not a great term for Paul Clement either. I mean, is that a reflection? I mean, is that a reflection on his lawyering? I mean, I'd be loath to say the SG's the quality of the representation there has somehow dramatically collapsed, and you know, or maybe now that Shri is gone, it will improve. I don't know. I can't say.
I mean, one thing you see, and sometimes it works and sometimes it doesn't, and it's probably a reaction to the very difficult job the SG has of trying to appease constituencies all throughout the federal government, is very often he takes a middle ground. You know, try to find something that gives everybody a little bit. And you know, sometimes that works, and in the Myriad case, it worked pretty perfectly because in Myriad, the middle ground was exactly what the justices adopted.
Anything more on that? Any questions? Yes.
Richard Samp of the Washington Legal Foundation. There was some discussion earlier of the Citizens United case, and I would say that's probably the case that has had the most criticism among liberals of the Supreme Court over the last 10 years. And so I guess and when I hear that criticism, the number one thing that you hear is that what are we doing giving First Amendment rights to corporations? And so I'd be curious whether each of you think that New York Times v. Sullivan was wrongly decided because it upheld First Amendment rights, and do you think that each of your employers ought to be protected by the First Amendment?
Well, I would just say that there is a separate grounds for the press. There's a separate press clause in the First Amendment, and so that it's really it's a independent grounds for the freedom of the press. That's a part. Press freedom doesn't really come up in the Citizens United case. It's a speech clause issue.
I basically agree with the premise of your question. I think that if corporations don't have speech rights, neither do media corporations. The press clause, I'm convinced, refers to a mode of communication, not a set of protected businesses. It's like the difference between libel and slander. Libel, written defamation; slander, oral defamation. And the press clause, it protects everyone's right to publish, not just a group of companies. So I think that's a powerful critique of Citizens United, a powerful critique of the critique of Citizens United.
I thought that decision was a failure of minimalism. I thought when that case was being argued, the question was, does a nonprofit political group have the right to put out political messages? And it seems to me all 9 of them sort of said, of course they do. And if the example were the Sierra Club or the NRA, most people would have said, yeah, sure, that makes sense. So these people come together, they've got a common views, they should be able to put out political ads. But how about ExxonMobil? And if any of you have pension plans or 401, you've got ExxonMobil, do you think you're stating a political view through ExxonMobil? And I thought that is what the Kennedy opinion jumps to. It was not argued. It's not even discussed. And Kennedy, when he talks about, if you ever hear Justice Kennedy talk about that, his example is always the Sierra Club or something. You know, it's a nonprofit where citizens come together and they have views. And I think the reason the American public was sort of taken aback by that. As I say, had they just said nonprofit political groups that incorporate can put out political ads, people would have said, well, that makes sense. But they were shocked to think that that meant that, you know, Walmart or Exxon Mobil could spend an unlimited amount to try to make or break political candidates. That struck people as different.
Any other questions? In the center here.
My name is Will. I'm an undergrad at Arkansas, and I just had a question about Shelby County for Adam, if that's all right. You mentioned that the decision itself was less statutory and less constitutional, and with the constitutional avoidance, it was just sort of the tacit conclusion that the article was really dumb. And my question is if there are any other cases brewing in the appellate court with that sort of, in any of the appellate court system, with the sort of admission that no Republican in North America is ever going to vote against the Voting Rights Act, so if you want to modernize it, you have to do it through the court. If they avoided the big question, are there any other cases that would eventually address the big question of the constitutionality of Section 5?
I don't see how it happens unless Congress fixes, as it won't, the coverage formula, which would then put Section 5 back up on its feet.
Yeah, on Shelby County. I thought Adam had a very good rundown of that case and the sort of the thinking behind it. I thought from a conservative audience, I thought that was also a failure of originalism. I'm sort of the skunk at the garden party here today, but the that struck me as one where Justice Scalia and Justice Thomas want to say, we are principled originalists. We decide cases based on what the Constitution says and what those provisions meant when they were passed. And as Adam said, the 15th Amendment was ratified in 1870. There were Union troops in the southern states, you know, in charge of the rebellious states. It said, you know, the right to vote shall not be abridged or denied on account of race. And it says Congress shall have the power to enforce this provision through appropriate legislation. So you get to 2013 and the Supreme Court says, well, there's this principle of equal sovereignty, which as Adam said, that's not anywhere in the Constitution. And nobody would have thought that in 1870, that it didn't allow Union troops to be in the South. And so if the amendment says Congress shall have the power, how does the Supreme Court say, no, we've thought about it and we've decided this Voting Rights Act is no longer needed?
No, it's inappropriate.
Yes, they could have said, we've decided it's inappropriate. But I thought that would have been a really interesting one to hear from Justice Scalia and Justice Thomas as to how this is an originalism opinion. It's we've thought about it and we've decided that the evidence that they relied on is not convincing to us, and so we're going to say it's inappropriate. It's a very much of a, you know, we're going to second guess what Congress decided. But I would love to have read the essay on how this was an example of originalism.
A couple minutes left. Any others? Way in back on the wall.
Hi, Andrew Kloster, Heritage. I just have a quick question, which is what the role of the courts, the Supreme Court in particular, is with sort of setting American tone for debate. I know in the abortion issue, the court has, and lower courts and commentators have for many years said, you know, reasonable people can disagree on abortion, and so we've had an ongoing discussion, a national dialogue. States keep passing additional laws, and sentiment has changed against abortion in many, many different states and among the younger generation. So my question is, when you have Justice Kennedy then changing his tone and having what seemed to me to be a very aggressive decision saying, you know, these laws are motivated by animus, in particular in the DOMA case, that people that pass these laws, you can pretty much only be motivated by animus, that there's, you know, when you're saying that only reasonable people can have sorts of opinions on one side of an issue, is this strategy by the court to sort of foreclose debate on this, realizing maybe the mistake that they made in the abortion context?
So that's a big, complicated question. The Supreme Court has many functions, not only to decide given cases. It's got a didactic function. It's got an agenda-setting function. People who study this stuff find that the issues that come before the Supreme Court, however it comes out, become much more salient in the public mind. People draw very different lessons from Rowan about what the court did there, whether it gave rise to a backlash, whether it got in the way of democratic liberal movement on that issue or not. I think a decision announcing a 50-state right to same-sex marriage might well have been problematic in the sense that people who criticize Roe on that ground think it was problematic. But this stuff cuts across many, many dimensions at once.
I think in changing the national discussion, the Kennedy opinion will ultimately affect it in a more narrow way, which is in the passages dealing with the interests of children, because children's interests have been a principal justification for laws restricting same-sex marriage. And in that decision, Justice Kennedy completely repudiates that view and takes the opposite position, that children are benefited if their parents can get married. And by that issue, what is the interest of children in terms of marriage laws, I think it may have a more a deeper impact than the general stuff about animus and so on.
David, we've got about a minute left, so I'll give you the last word.
I don't have anything further to add on to that one.
Okay, thanks very much. Thanks, guys, for coming. We're concluded.